Hello students and welcome to Chapter 14 Legality. I know we started this in class the other day, but I'm going to start from the beginning of Chapter 14 and work our way through to be assured we've covered all the material in order to properly prepare for the quiz, which will be due Sunday at 11:59 on Chapter 14. You'll want to listen to this lecture, read the Chapter 14 in the text, do the practice questions at the end, and review this PowerPoint that I'm going to talk about today. Okay, so legality, all contracts need to be legal, and there's also a YouTube video that you might want to watch, which I included the link on the first slide of the Chapter 14 PowerPoint. So there are two categories of illegality that we talked about. Illegal agreements fall into two groups, ones that violate a statute and one that violate public policy and are designed to protect our society and us as citizens. Examples of contract illegality are wagers, licensing statutes, and usury. What is a wager? A gambling contract is illegal unless it's specifically authorized by statute. And we talked about this in class. Licensing statute, when a licensing requirement protects the public, any contract made by an unlicensed worker is unenforceable. And we talked about electricians need to be licensed to do work, doctors need to be licensed to practice medicine, attorneys need to be licensed to practice law in order to recover on a contract, right? When a licensing requirement is designed merely to raise revenue, a contract made by an unlicensed person is generally enforceable, because we talked about our example of licensing statutes, a store that's required to be licensed by the state in order to run a business. If they accidentally let their license lapse and they're still practicing business, they might be fined or required to continue that license. Those are just revenue raising statutes. Okay, usury. We know usury laws protect charging excess interest on loans. And we talked about credit cards and mortgage loans and car loans. And there are links. We talked about certain states like Delaware provide better benefits for banks, and so banks often state shop, so they have the most rights. And when we last met, we watched the John Oliver YouTube video in my 9:30 class, but in my 5:30 class, you're going to want to watch that YouTube video. It's a John Oliver clip on usury, and it's very interesting and entertaining in my opinion. All right, contracts that violate public policy. Examples of these are restraint of trade or non-compete agreements, and we'll talk about that, exculpatory clauses, bailment clauses, unconscionable contracts, and adhesion contracts. So let's talk about those. The next slide is restraint of trade. To be valid, an agreement not to compete must be ancillary to a legitimate bargain. I'll repeat that. To be valid, an agreement not to compete must be ancillary to a legitimate bargain. What agreements not to compete are? There covenants not to compete, right? Or restrictive covenants. So in a sale of a business, when a non-compete agreement is ancillary to the sale of business, it is enforceable if it's reasonable in time, geographic area, and the scope of activity. And we talked about that in the morning class. With respect to an employment contract, a non-compete clause of an employment contract is generally enforceable only if it's essential to the employer, fair to the employee, and harmless to the general public. And we talked about non-compete clauses, and that is the balancing act that a judge would do. They would determine whether in an employment contract if this covenant not to compete is essential to the employer, fair to the employee, and harmless to the general public. And a non-compete agreement, when it's ancillary to the sale of business, is enforceable if it's reasonable in time, geographic area, and scope of activity. Okay, exculpatory clauses. The definition of an exculpatory clause is where part of a contract that attempts to release you from liability for injury to another party. Okay, so what are examples of exculpatory clauses? That is in a contract or part of a contract that attempts to release you from liability for injury to another party would be if you sign a release that you promise not to sue a business, right, if you get hurt on their premises. They're generally unenforceable when, and these are important to know, the affected activity is in the public interest, such as medical care, public transportation, or some essential service. When it attempts to exclude an intentional tort or gross negligence, the parties have generally unequal bargaining power, and it is not clearly written or readily visible. Bailment cases. Exculpatory clauses are very common in bailment cases. And what is bailment? Bailment means giving possession and control of personal property to another person. The person giving up possession is the bailor, and the one accepting possession is the bailee. There are examples in the text. I suggest you look at them. What are examples of bailment? Examples of bailment are if you leave your car in a parking garage, you're giving possession and control of personal property to another person, at least temporarily. When you drop your clothes off at a dry cleaner, you're creating a bailment arrangement. Unconscionable contracts. An unconscionable contract is one that a court refuses to enforce because of fundamental unfairness. The two factors that most often led a court to find unconscionability are: one, oppression, meaning that one party used its superior power to force a contract on the weaker party; and two, surprise, meaning that the weaker party did not fully understand the consequences of its agreement. Wow, that was so unconscionable, right? Either the party was oppressed, right, meaning the one party used its superior power to force a contract on the weaker party, or there was surprise, meaning the weaker party did not fully understand the consequences of this agreement. And look at the text under unconscionable contracts. There are examples and I think sample questions too. Adhesion contracts. Adhesion contracts are standard form contracts prepared by one party and given to the other on a take it or leave it basis. They are generally enforced when two parties are of equal power, but when the parties are unequal, the contract may be ruled as unconscionable, like we talked about in the other slide. So what's an example of an adhesion contract? They're standard form contracts prepared by one party and given to another on a take it or leave it basis. So an example of an adhesion contract would be when you want to download software on a computer, right? It gives you all the terms and conditions and says, read all these like 20 pages, and if you agree, just click yes at the bottom and we'll allow you to download the software. You know that unless you agree to the terms, they won't allow you to download the software. But these are adhesion contracts where they're take it or leave it. Either you sign this and you accept the terms and you download the software, or you don't, right? Another example, if you download apps, you have to agree to certain terms, right? So those are examples of adhesion contracts, which most of us we know don't read those, but it's in your best interest to do that. Okay. What does the UCC say about unconscionability? With the creation of the UCC, the law of unconscionability got a boost. The code explicitly adopts unconscionability as a reason to reject a contract. Although the code directly applies only to the sale of goods, we know that UCC applies to the sale of goods, its unconscionability section has proven to be influential in other cases as well. The courts today are more receptive than they were 100 years ago to a contract defense of fundamental unfairness. Adhesion contracts versus unconscionable contracts. Contract of adhesion versus unconscionable contract. A contract of adhesion is a standard form contract usually created by one party with a much stronger bargaining power that another party will have to either sign as is or reject it, like our check the box if you're downloading software. The weaker party will not have an opportunity to negotiate the terms of the contract. When you download an app, you must agree to the terms and conditions of the app before using it. You're facing a contract of adhesion. And those type of adhesion contracts often have you agree to binding arbitration instead of being able to sue if you have an issue, but all those terms are embedded in this long contract that you must agree to the terms in order to download the app. Okay, courts will usually enforce contracts of adhesion. That is, if a person signs an adhesion contract, they must comply with the terms. Versus an unconscionable contract is a contract that is so unfair a court probably shouldn't enforce it. If a person is forced to sign a contract or lacks a reasonable opportunity to review it, and the court includes very unfair, and the contract can includes very unfair conditions, a court probably will consider it an enforceable contract. That is, if a person signs an unconscionable contract, a court might not force him to comply with the terms. Okay? All right, so that is the complete Chapter 14 PowerPoint. We will have a Zoom office hour live session on Wednesday at 9:30 a.m. and Wednesday at 5:30 p.m. You can log on for one or the other, regardless of which section of class you're in for Business Law 115, or none at all. It's optional. I'm happy to talk about the subject matter, give examples. We could do practice questions. So you're welcome to log on. I've sent you the link in an email, and it's also in the announcement for the 9:30 a.m. Wednesday Zoom meeting and the 5:30 Wednesday Zoom meeting, which I will have every week moving forward. Okay, so come prepared with your questions. Thanks, guys.